Good morning, everyone. Merry stupid o'clock to one and all. Welcome to another episode of Smelling Tea. I am your host, Tiffany Daniels, and apparently suffering severely today from fall allergies. So keep that in mind, guys, if I have a coughing fit. We're going back to that horrible world known as the JRC, but before we get going this morning, a few of the usual disclaimers. First off, you are going to find the link to the legal documents that we are going over this morning right there in the description box, as well as the other pertinent links to the Stop the Shocks campaign. Now, folks, if you are brand new to this and have never heard of the JRC before, I encourage you to go to the description box. There is quite a few links in there. Uh, Look at the Autistic Hoya's massive archive on the subject. It is linked in the description box. Also, you can get a crash course by going onto YouTube and typing in Judge Rotenberg Center. One of the listed videos is from a former employee called Greg Miller. He has a compilation video that will give you a crash course into the JRC and what they do there. Also, we have included in the links, like mentioned, Autistic Hoya's massive archive on the subject. We have the templates. Folks, sign your name, click on your senator, that's in aversive punishments and improper restraints and seclusion in schools. It takes lives every single year. We also have the ever-present change.org Shut the Judge Rotenberg Center Down petition. If you haven't signed it yet, please do. Please go ahead and share on all your social media pages. Now, folks, when we talk about the JRC, you're going to hear vivid descriptions of, as well as see clips of surveillance footage of, peoples with disabilities being tortured and abused. If you have young children present, please use your headphones. Now, folks, it is 3:18, stupid o'clock a.m. in the morning. So if I stumble over my words this morning, my apologies in advance. Now we're going off to where we left off yesterday. DDS's 2011 regulation banning level 3 aversives is a significant factual and legal change warranting relief. Remember, this is a law that was passed not that long ago. These are regulations that they banned back in 2013 that somehow JRC continues to skirt around because of that 1988 settlement. So even though the rest of the state has to comply with it, they get that special treatment. So we're going to go ahead and going over that this morning. Also, folks, goes without saying, drink your calming tea, okay? God, I hate allergies. All right, so interviewing law that conflicts with the requirements of a decree constitutes a significant change, which courts have characterized as both legal and factual, justifying modification under Rule 60B 5C Horn 557 U.S. at 459 through 468, Rufo 502 U.S. at 388, and DDS's 2011 regulation qualifies as a relevant change under this standard. As mentioned, JRC has consistently taken the position that Part A of the decree gives it the affirmative right to use aversives, irrespective of the DDS regulations. Again, they think that they are above the law because of that 1988 settlement. They use it as a way to get away with torture, folks. It's unbelievable what they are allowed to get away with. and the fact that the courts keep protecting them. In spite of what the DDS, who has been given the authority to regulate and the power to revoke or to give licensing for operation to all the other places in the state of Massachusetts that serve people with developmental disabilities. Okay, let's continue. That position cannot, however, be reconciled with the new regulation, which affirmatively bans the use of adversives on a prospective basis, 115 CMR 5.14, nor can the regulation be reconciled with JRC's position that it has the right to arbitrate any dispute concerning the availability of adversives. Because the regulation is consistent with accepted professional practices, neither the court monitor nor the court itself has the authority to prohibit DDS from enforcing the regulation against JRC. See McKnight 406 Mass at 798-801. Probate court lacked authority to issue permanent injunction directing that aversives be available for use by JRC because, if accepted professional practices would tolerate the unavailability or the non-use of adversives, and the department elects to follow that professional practice, the courts must respect that judgment. Guardianship of Anthony, 402 Mass at 727. Probate court impermissibly poached on executive and legislative territories when it ordered AIDS tests on residents of DMH regulated facility in absence of evidence that the testing for AIDS was inappropriate, let alone the only means by which DMH could fulfill its statutory duties. Accordingly, the decree, as historically interpreted and invoked by JRC, presents an inherent conflict with the regulation, which was promulgated in full compliance with Chapter 30A. For this additional reason, Part A of the decree should be stricken or vacated. See Horn 557 U.S. at 461 through 64, remanding for considerator of new statute that marked shift in federal education policy, which court found could warrant modification of injunction that conflicted with that policy. Calderin versus Wambua, number 74, civil case 4868, 2012, WL 1075840 at 4 through 6, SDNY, March 28, 2012, vacating parts of the decree that mandated procedures that city had to follow before promulgating regulations, where city later adopted an administrative procedure statute that made compliance with the decree substantially more onerous. In alternative, the decree should be vacated under Mass R Civ P 60B5 because it has been satisfied. Rule 60B also authorizes relief from judgment if the judgment has been satisfied, released, or discharged. Vacator of the decree is warranted on this alternative basis. As discussed above in Part 1B, the decree provides for termination after the second 6-month review, and the sole basis for the extension order was that, at the time, JRC was not fully licensed. JRC has been licensed and certified at least as of the mid-1990s and has been recertified numerous times thereafter. Thus, under the plain language of the decree and the extension order, the decree has been satisfied and should be vacated. See Consumer Advisory Board 697, Supplemental 2D at 135 through 37. Consent decree was satisfied under Rule 60B5, where state substantially complied with its benchmarks. Conclusion. For the above reasons, this court should enter the judgment vacating the consent decree and terminating its jurisdiction over this case. Okay, so we have a few arguments through this document, and in order to vacate the consent decree of 1988. Number one, as stated here, all the demands of this particular case have already been satisfied. The JRC has been fully licensed and has been several times since the 1988 settlement agreement. Also, that time period and its extension has long ago come and gone. Also, they have also received remedy for their quote-unquote grievances. Therefore, as their licensing as of right now is not on the line, then why is it still in place? Another point that they are bringing up is that as of right now, the procedures and practices in the Level 3 adversives used at the JRC no longer meet the standard practice of care, not only in all other 50 states in the Union here, but also in Massachusetts itself. Massachusetts, as a state, has gone ahead and banned Level 3 adversives everywhere except at JRC, because the courts continue to use, and the JRC continues to use, that 1988 settlement for them to be the exception, which is insane, completely insane. So it does not meet standard practice for any of the 50 states here. Also, it doesn't meet the practices and standards of its own state everywhere else. They also bring up the point that it is extremely unfair for the JRC to be able to have this special treatment in regards to receiving and the renewing of their licenses every year in spite of using Level 3 adversives, when every single center operating in the state of Massachusetts that serves people with mental issues and developmental disabilities absolutely have to make sure they follow these regulations to the letter in order to receive their licenses for operating every year. No other place in operation in the state of Massachusetts has this ability to skirt itself around the law or around DDS's authority. And they also bring up the point that this is ridiculous. No court should have jurisdiction to rule over this forever. This was not meant to go on in perpetuity. DDS should have the right to do as they do with all the other centers in operation in the state of Massachusetts, to be able to regulate the JRC and decide if they do not meet regulations that they do not get licensed, just like with every other center in the state. And the most pertinent of it all, it states again, these so-called treatments have been proven over the years to be absolutely pointless. They do not do what the JRC tells you that they do. They do not get rid of the quote-unquote challenging behaviors. More often than not, it makes them worse. You are literally punishing disabled people for being disabled and not giving those disabled people any remedy or any chance to challenge the court-ordered treatment. You're using this 1988 settlement to have complete, absolute power. And the courts continue to back it up every single time. We're using an agreement that should have been satisfied a long goddamn time ago. You have a state agency whose very job function it is to regulate and license these programs and services for people with disabilities in the area. It is their job to regulate them and make sure that there is no abuse or torture or any sort of way that the human and civil rights with the person with disabilities is being violated in any way. That is their job. That is their statute. And then you have the JRC, who uses past actions of a predecessor state agency in order to not have to come into compliance with the very regulations set in place by their DDH in order to protect the people with disabilities who are receiving those services. It's ridiculous, and it should have been vacated a long time ago. But in spite of what we read this morning, that was out in 2013, folks. And we are still fighting this ridiculous fight. And that 1988 settlement agreement is still in place, still being backed up. And the JRC are still literally getting away with murder. And on that note, folks, I'm going to go ahead and close out for this morning. But before I do, we have some people who are new to this case. So I wanted to make sure to go ahead and play a video to give a brief rundown to those who are new to this as to what JRC is doing and why we're fighting them so hard. So Dwight, if you're watching this is what this whole case is about. Now, for those not familiar, we're not talking about regular ECT. This is painful skin shock treatment. And this is going to give you a brief overview of what's going on, okay? I'm going to have to rewind this here.
Screams of pain from a student at the Judge Rotenberg Center as he's tied down and shocked for hours. Good evening, I'm Mark Cochran.
Hi, everybody. I'm Maria Stefanos. Fox Undercover's camera, the only one in court today, as a jury is given its first look at that disturbing video. We want to warn you that the video is tough to watch. Mike Beaudet reports.
This is the video that the Judge Rotenberg Center in Canton has fought long and hard to keep from the public eye. The center convinced a judge 8 years ago to seal it, and the battle continued right up until it was played in court, as lawyers for the center asked the judge to bar our camera from recording it. The judge said no, and now for the first time ever, the public can see for itself what these controversial electric shocks look like in use. Dramatic video of New York teenager Andre McCollins, restrained face down, a helmet on his head, screaming for help. Judge Rotenberg Center calls it treatment.
I was shocked when I was 16 or 17. I was 31 that day.
As McCollins' attorney just described, the teenager was shocked 31 times in all that day in 2002. And McCollins is suing the Canton-based center, calling it torture. Lawyers for the center and its clinicians say McCollins needed aversive therapy because he was aggressive.
These are dramatic tapes. There's no question about that.
He literally refused to move his coat. Yes, so aggressive.
The treatment plan that Andre had in place on October 25 was followed.
It was an emotional day for McCollins' mother, Cheryl, who was in court as video was played from the beginning of Andre's ordeal, when he was shocked and restrained after refusing to take off his coat.
I never signed up for him to be tortured, terrorized, and abused. I had no idea that they tortured the children in the school.
Cheryl testified what her son was like when she visited him 3 days later.
I couldn't turn Andre's head to the left, to the right. He was just staring straight. I took my hands and I went like this. He didn't blink.
Cheryl McCollins did get Andre to Children's Hospital that day, where he was diagnosed with acute stress response caused by the shocks. The jury also heard her testify about watching the video and hearing staff members laughing while their son was on the floor. We should see more video on Wednesday in court as Cheryl McCollins returns to the witness stand. I'm Mike Bodette for Fox Undercover.
Okay, so that should give you a good idea of what the JRC is doing, what they have been doing since 1976 when they are founded. And on those dark notes, we're going to go ahead and close out this morning. We don't get very many views on this channel, especially on this very tough subject. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.